Well, hello, my name is John Watts. I'm a foreclosure defense attorney in Alabama, and I wanted to shoot this quick video. This is a Friday afternoon, September 1st, and the reason I want to do this is there was a really important case the Alabama Supreme Court released just today that gives tremendous help to homeowners. And a couple of my friends handled this case. Ken Lay and Rhonda Hood did a fantastic job on it. And in a sense, this case doesn't do anything new, but here's what it does. It reminds everybody that we're going to stick with the law just as it is written, which means your mortgage, that's the document that gives your mortgage company the right to foreclose, it has to be complied with very strictly by the mortgage company. See, what's happened over the years is the mortgage companies, let's imagine the mortgage requires them to do 5 things. They'll say, well, we're going to do 2 of them. It's good enough. And a lot of judges have said that's okay. No more. The Alabama Supreme Court just emphatically said today, you must follow the law. And so the name of this case is Turner versus Wells Fargo. Let me give you the real quick background. So the Turners have a loan. They get what's called a default notice. And that says, hey, you're in default. You have 30 days to fix it or cure it. And if you don't do that, we're going to accelerate the loan. So instead of you having 30 years to pay off your mortgage, it's all due right now. And we'll foreclose. Well, nothing happened. And so the mortgage company foreclosed. Then they say, hey, get out of the house. Turner say, no, we're not. We don't think this was done properly. So Wells Fargo sues them in what we call an ejectment case. And then the Turners say, well, wait a minute. Wells Fargo, or the servicers, a company called Carrington, you didn't do this right. You did not follow the mortgage, because the mortgage says when you send us that letter that threatens us with foreclosure, you have to tell us we have the right to go to court to have our defenses heard. And what Wells Fargo or the servicer actually sent was a letter just saying, you have the right to have your defenses heard. Well, see, in Alabama, we're a non-judicial foreclosure state. So there is no foreclosure lawsuit. It's different than Florida. So to just say, oh, by the way, you can have your defenses heard, well, typical borrower, homeowner is going to say, okay, well, I guess there's going to be a court lawsuit against me and then I can defend myself. But that's not how it works here. Here, the mortgage company just says, you know what? We're foreclosing. Boom, your house is foreclosed. And there's no lawsuit. And once you get to that point of foreclosure, now they're suing you for ejectment, your options are more limited. So the Turners argued to the Alabama Supreme Court, look, we should have received the exact notice that our mortgage requires. And the trial judge said, nah, it's good enough. Court of Civil Appeals said, yeah, it's not exactly right, but it's close enough. Wells Fargo is saying, no big deal, don't worry about this. The Alabama Supreme Court says, look, if you guys are going to do these non-judicial foreclosures, it's a tremendous advantage to you to do that. But here's what you have to do. You must follow the law exactly. You must follow the mortgage exactly. And Wells Fargo did not do that. And so ultimately the Alabama Supreme Court held that foreclosure sale is invalid. Because if you don't do every step right leading up to the foreclosure, then it's kind of like a house built on a poor foundation. Remove the foundation, it all falls apart. And so here's the real takeaway lesson here. And we've been harping on this. When you are facing a foreclosure, your number one way to stop the foreclosure, not to go file bankruptcy, not to cross your fingers and hope maybe they'll cancel the sale. Sue them. Sue your mortgage company. You have the right under the mortgage. Look in your mortgage. It's probably paragraph 22 or somewhere near there, but typically it's paragraph 22. And that lays out, like, here's what the mortgage company can do. They have to send you this default letter. Then they can accelerate. Then they can advertise it in newspaper for 3 consecutive weeks. And they must tell you you have the right to bring a court action to have your defenses heard. Defenses to being in default, defenses to the foreclosure. You have the right to do that. So look at your mortgage. Do you have the right to do that? Well, then take advantage of that. file suit. Get a judge to look at this. There's so much fraud, corruption in the mortgage industry. Why would we ever trust the mortgage companies that can't get things right? Why would we ever trust them to get the foreclosure right? We want a judge to look at this and say, hey, we messed up. They get to foreclose. Or wait a minute, mortgage company, you've messed up. You do not get to foreclose. So look at that. Look also at your acceleration letter, your default letter. These should be letters you received. Let's say the foreclosures next week, then you would have received your acceleration letter probably about 30 days ago, default letter about 60 days ago. Read those, look at them very carefully. Do they say that you have the right to bring a court action to have your defenses heard? And so you get the letter and you get your mortgage and you kind of look at them and do these things match up? And if you have any questions about this, you live in Alabama, feel free to give us a call. 205-879-2447 or alabamaconsumer.com is our main website. You can go there, contact us. But you really need to take immediate action. I mean, go pull your mortgage, go pull the acceleration letter, go pull the default letter, lay these out on your kitchen table, start looking at them. And then if you have any questions or you want any help with this, give us a call, 205-879-2447, and wish you the best. And thanks for watching this. I know it's a little bit lengthy video, but I just read this opinion and wanted to share it with you because I think it's so important that you understand what your rights are and that you're encouraged to take the right action to save your home, because I don't want you to lose your home. Okay, take care. Bye-bye.